Any mention? Lordship, I beg to mention item number 2 and 3 from the daily list. Doesn't matter. I pray that the matter may come up after vacation, Your Lordship.
Who is the other side?
Yes, I have already informed them.
You have already informed them?
Yes.
Yes. Yes. Please by the line of counsel for the petitioner. This is matter of vacation. Yes. 2 and 3. Yes.
Supplementary cause list. Item number 1.
May it please your lordships.
Yes. What is this?
My lord, it's an application under section 482 seeking, my lord, interference with the investigation. Now, if your lordship kindly permits me, I can place the FIR, my lord.
Yes.
FIR is at page number 124.
May it please your lordship. Lordship, before my friends start, lordship, it appears, your lordship, that this is 482, your lordship. It should have been under the new court, not under the 482.
Why the FIR is registered under what section of law?
In
Under the old sections, my lord.
Then it's all right. What is the problem in it?
Now, please come to, my lord, page number 138, or rather 139.
178.
139, my lord, the type copy of the FIR.
No, there is no such page 39.
139.
139. We don't have 139.
There is no 139.
There is no 139. There is no 139.
Okay.
Petition ends at page 136.
I think lordship is taking up item number 1 or 2, my lord.
Yes, Subayan Nagarajan.
No, the lordship will kindly take the item number 2, my lord.
Why not item number 1?
My lord, same FIR, my lord. We have made the preparations in item number 2. I'm sorry
1
for
and
the
2, these are connected to us.
Yes, my lord, arising out of the same FIR. I'm sorry for that
No,
inconvenience.
actually, item number 1 was called, so that is the.
I'm sorry, yes, correct, my lord. Now, my lords will kindly come to page 139. May I read it, my lord?
Yes, please.
Yes. The director of Meghalaya State Lottery Shillong, entrusted with the function of promoting, organizing, conducting, and to do all other allied works relating to lotteries in accordance with the relevant provisions of Lottery Regulation Act 1998, the Lottery Regulation Rules 2010, and Meghalaya Lottery Regulation Rules 2019. The government of Meghalaya has published a notice dated 28/3/22 for inviting expression of interest from eligible parties for appointment of distributor for operation of marketing of paper and online lotteries on behalf of the government of Meghalaya under the relevant provisions of the Lotteries Regulation Act and Meghalaya Lottery Regulation Rules 2019. Thereafter, one C. So-and-so Enterprise Network Private Limited, Chennai, has submitted its expression of interest dated 28/03/2022. Upon careful consideration, the government of Meghalaya, by letter dated 27/6/22, has accepted the expression of interest of the said Aspirastar Entertainment Networks Private Limited, and by an agreement dated 16/9/22, one Messrs. Aspirastar Entertainment Network Private Limited, Chennai, has been appointed as distributor to conduct marketing and sale of all kind of lottery schemes, online and paper, on behalf of the government of Meghalaya under the relevant provisions of Meghalaya Lottery Regulation Rules 2019, etc. Further, the said distributor has formed a special purpose vehicle, i.e. Amudra Innovations Private Limited at Shillong. Apart from the above said distributor, one Messrs. Utchip Gaming Private Limited at Tezpur, Assam has submitted its expression of interest dated 28/3/22, and upon careful consideration, the government of Meghalaya by letter dated 27/6/22 has accepted the expression of interest of Messrs. Utchip Gaming Private Limited. Thereafter, the government of Meghalaya has entered into a distribution agreement dated 31/8/22 with Messrs. Woodship Gaming Private Limited to conduct marketing and sale of all kind of lottery schemes on behalf of the government of Meghalaya under the relevant provisions of Meghalaya Lottery Regulation Rules 2019, etc. Further, the said distributor has formed a special purpose vehicle, that is Eastern Infotech Private Limited at Kolkata. The information regarding appointment of distributor was also communicated to the director of the state lotteries in various states. So my lord, what is evident is, pursuant to the expression of interest, two entities were appointed as distributor of Meghalaya State Lottery. Subsequently, Government of Meghalaya wide communication dated 25/8/23 has informed the distributor Woodship Gaming Private Limited and its SPV so-and-so at Kolkata that a lottery draw scheme, Singham Weekly Draw, has been formulated by the state government of Meghalaya for conducting lottery draws. The details of the draws under this scheme are as follows. Serial number 1, Wednesday draw, name Singham. So these were the different lottery schemes. As per the terms and conditions of distributions agreement and as per the relevant provisions, the first draw was held on 30/8/2023 under the name Singham Wednesday Weekly Lottery, and thereafter the results with the winning tickets were also published. Well, this date has a relevance. I'll come to its significance little later, this 30/8/23. This being so, now this is where, my lord, the allegation starts against the present petitioners. The office of this Directorate of Meghalaya State Lottery has reliably learned that Mr. Martin Santiago, Managing Director of Messrs. Future Gaming Hotel Services Private Limited, having its registered office at so-and-so, who is close, and Mr. S. Nagarajan, who is close associate of Mr. Martin Santiago, conspiring together and indulging in illegal activities of criminally intimidating, threatening, coercing, and causing undue influence on the stockist and sub-stockist and others in order to destroy the competition, since the named persons are practicing monopoly in the field of lottery business. The criminal activity of the above persons caused loss to the exchequer of the state government of Meghalaya. The persons referred to above have been unlawfully preventing the official distribution and business of the Meghalaya state lotteries continuously through various illegal means of criminality, threatening the stockists and others, and also by manipulating them with false and defamatory information to curtail the distribution of Meghalaya state lottery at Police Bazar, Shillong, and other parts of Meghalaya and other states, that is West Bengal, Punjab, Maharashtra, etc. That it is pertinent here to mention that the said Martin Santiago, through their associate Mr. Subayan Nagarajan, henchmen and gangsters, gave continuous and serious threat to the stockist, sub-stockist and others, and thereby prevented them from carrying out the business with the Meghalaya State Lottery. The said illegal activities carried out by Martin Santiago and his associate Subayan Nagarajan through their antisocial elements caused a huge business loss to the Meghalaya State Lottery, approximately to the tune of rupees 1,500 crores, by indulging in criminal activities of threat, coercion, undue influence, criminal intimidation, etc. The said sum of 1,500 crore is an approximate loss caused to the Meghalaya State Lottery, and said amount was indirectly diverted to the income of the company owned by Martin Santiago and his associate Mr. Subayan Nagarajan. That apart, this office of Meghalaya State Lottery also came to know that the said Martin Santiago and Subayam Nagarajan, through their henchmen and rowdy elements, has been indulging in antisocial activities and eliminated several competition by illegal means for the past several years and has been accumulating several crores through illegal means. The persons referred to above have been strenuously spreading defamatory and false information in person and also through electronic mode against the lottery business of the Meghalaya State Lottery, and also cause undue influence and coercion with intent to apprehend fear among the stockists and others and thereby illegally gain undue advantage. So basic allegation is, my lord, these two gentlemen, that is Martin and Mr. Nagarajan, they have committed offences according to the FIR, my lord. If your lordships will kindly come to page number 135.
Yes.
Kindly see these sections, my lord, under which one is 406, other is 420, 426, 500, that is criminal defamation, 506 is criminal intimidation, 120B and 34. So, my lord, basically the allegation is these are the offences which has been allegedly committed based on the allegations incorporated in the FIR. Now, I'll explain to your lordships why there are no ingredients of either of these sections in order to enable the police to, my lord, register the case. My lord, as far as registering of the case is concerned, that may not have any relevance. But question is whether you can investigate. That's the issue, my lord. Because, my lord, under the scheme of the CRPC, 154 is the power regarding registration of FIR. And 156 and 157 are the power of investigation. And especially, my lord, 157 says how to proceed with the investigation. So it is in that context, my lord, I'll make my submissions. Now, my lord, will kindly see this serial number 3. Now, kindly see occurrence of offence. They say it is 28/3/22. Then, my lord, information received at PS 11/9/23. And my lord will kindly come to serial number 5 at page 136. Place of occurrence.
Occurrence of offence means is only one day. Date from 28/3, date 2 also
23. Yes. No, my lord. Now,
it is not a case that on the several occasions that was it.
No. Precisely. I am very obliged to your lordship. Now, my lord will kindly come to page number 143 for a moment. Now, they are saying that state of Meghalaya has incurred a loss of 1,500 crore. How inherently improbable the allegation is, that I will demonstrate. Kindly come to page 143, my lord.
Yes.
Para 9. Last few lines. Three lines.
Para 9, para 10 now.
Para 9 and 10, yes, my lord. So they say 1,500 crore has been lost by state of Meghalaya. Now, my lord, kindly see 38/23 is the date when, that is the date from which, my lord, this Singham thing was launched. And what is the outer limit? 11/9/23. Information received. Within a period of 13 days, my lord, 1,500 crore has been lost by the government of Meghalaya. And most importantly, my lord, on 28/3/22, these stockists were not even appointed. Agreement is of, my lord, agreement is of 38, what is the date agreement? 31/8/23, 22. Two agreements, one with Uchip and other with other party, my lord. The agreement is of 16/9 and 31/8, 22. And they say occurrence is of 28/3/22, when stockists were not even appointed.
Just repeat the date, please.
Yes, my lord. If your lordships would kindly come to page 140 for a moment.
Yes.
Para 4.
Yes.
This stockist, Aspirestar Entertainment Network Private Limited, they were appointed on 16/9/22. Am I clear, my lord? Yes. Then please come to para 5, my lord. Fifth line from bottom. This Woodship Gaming was appointed on 31/8/22. Now come to page 135. They say on 28/3/22 is the date of occurrence. 28/3/22, no stockists were there because the distributor itself was not appointed.
22, it's 23. Occurrence is 23.
No, my lord, 22.
22.
Yes.
Now this FIR was filed on which date?
FIR was filed on 11/9/23. FIR was also filed, my lord, after
More
1
than
year.
1.5 years.
And a place of occurrence, my lord, office of the director, Shillong. My lord, right hand does not know what left hand is doing. So, my lord, these are all inherently improbable and, my lord, malicious allegations. My lord, I am not a non-entity. I have been given permission by the Meghalaya. I am basically a distributor of state of Nagaland lottery. So I have been permitted by state of Meghalaya to sell lottery tickets of my lord Nagaland in the state of Meghalaya. That is how I am here. So my lord, my first point is the so-called date of occurrence, on the so-called date of occurrence, the stockists were not even appointed. Stockists were appointed, one on 31/8 and other on 16/9.
What about the paragraph 10
Yes.
at page 143,
Yes, my lord.
which says that it is going to pass several years? The last part.
No,
You
my
see
lord.
the
Yes.
last line.
No, my lord, lordship will have to see the totality of the allegations. Now, they cannot, my lord, digress from what they have, said in page 135. Occurrence is 28/3/22. Now, my lord, may I place before lordships section 157 of this?
So far as the FIR, contents of the FIR is concerned,
Yes.
no such date is mentioned.
No, but my lord, it is the satisfaction of the investigating officer. My lord, that's why I was trying to place 157 for a moment, my lord. What are the steps which are required to be taken by an investigating officer when he decides to, my lord, investigate a matter? And what are the legal recourse he has to undertake? And if it is not taken, what is the consequence in law? In Vajanlal's case, my lord, these aspects were clearly laid down. Now, my lord, if we look at the allegations one by one section, my lord, now first they say it's a case of criminal breach of trust. Who has entrusted whom what property? Now, my lord, where is the inducement? Who has induced whom to be cheated, my lord? So 420 goes. My lord, then, my lord, a 426 mischief lordship knows that unless there is a physical injury, it cannot be attracted. And 500 criminal defamation can't be by of an FIR. There has to be a normal complaint. Now, where is what alarm has been caused by this, my lord, that to invoke 4506? So, my lord, prima facie, the allegations contained in the FIR taken in its face value does not constitute any of the offences alleged. Now, most importantly, if your lordships will kindly come to page number 132, my lord. Page number 132.
Yes, what is this?
Yes. Received White Shillong Shodor PS case number so and so on 11/9/23 and a cognizable case registered White so and so under section 406, 420, 426, 500, 526, 120B, 34 IPC and Sri so and so to investigate the case. Is this the requirement of 157, my lord? There is no other requirement? That's why I'm saying, my lord, please permit me to place page 157 for a moment, my lord. CRPC, my lord. I'm sorry, my lord. I'll have your lordship's kind attention to section 157 CRPC.
Yes.
Procedure for investigation. If from the information received or otherwise, an officer in charge of the police station has reasons to suspect the commission of an offence which is empowered under section 156 to investigate, he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offence upon a police report, and shall proceed in person or shall depute one of his subordinate officer not below the such rank as state government may by general or special order prescribe in this behalf to proceed to the spot to investigate the facts and circumstances of the case, and if necessary to take measures for discovery and arrest of the offender. Now this proviso is very important, beloved, especially B, provided that if it appears to the officer in charge of the police station that there is no sufficient ground for entering on an investigation, he shall not investigate the case. With all sincerity at my command, my lord, with all humility at my command, I respectfully submit, my lord, the moment an FIR is registered under 54 or filed under, my lord, accepted by the police through a GD entry, before investigating, an investigating officer is cast with a legal duty to record his satisfaction regarding that a cognizable offence has been committed. It's not automatic, my lord. It is not something like
What is the consequence of default?
my lord.
What is the consequence?
Consequence of default is, my lord, lordships will interfere with. That's what I'm going to, that judgment I'm going to place. Consequence of default is, my lord, answer is bhajan law. My lord will kindly come to para 35. At page 355. The next question that arises for consideration is whether registration of a criminal case under section 154(1) of the code ipso facto warrants setting in motion of an investigation under chapter 12 of the code. This was the precise question which was posed by the Honorable Supreme Court. Section 157(1) requires an officer in charge of a police station who from information received or otherwise has reasons to suspect the commission of an offence, that is a cognizable offence which is empowered to investigate under section 156, to forthwith send the report to a magistrate empowered to take cognizance of such offence upon a police report, and to either proceed in person or depute any one of his subordinate officer not below such rank as the state government may by general or special order prescribe in this behalf, to proceed to the spot to investigate the facts and circumstances of the case, and if necessary to take measure for discovery and arrest of the offender. This provision is qualified by a proviso which is in two parts, A and B. As per A, the officer in charge of the police station need not proceed in person or depute a subordinate officer to make an investigation on the spot if the information as to the commission of any such offence is given against any person by name, and the case is not of a serious nature. We are not concerned with A, we are concerned with B. Now this is important. According to clause B, if it appears to the officer in charge of a police station there is no sufficient ground for entering on an investigation, he shall not investigate the case. Subsection 2 of section 157 demands that in each case and each of the case mentioned in clause N B of the proviso to subsection 1 of section 157, the officer in charge of the police station must state in his report, required to be forwarded to the magistrate, his reason for not only complying with the requirement of subsection 1, and when the police officer decides not to investigate the case for reasons mentioned in clause B of the proviso, he in addition to his report to the magistrate must forthwith notify to the informant, if any, in such manner as may be prescribed by the government, state government, the fact that he will not investigate the case or the case or cause the case to be investigated. Section 156(1), which is to be read in so and so, so and so. Then my lord will kindly come to para 41 at page 359.
Now the report, the
My lord.
page 132, which you have shown just us.
Yes, my lord.
It is not a
132, my
forwarding
lord.
report to the
Yes,
magistrate.
yes.
It is not a forwarding report to the magistrate.
No, it's not a forwarding report, my lord.
What has been contemplated in Bhajanda's case
Yes.
is that
Ah,
while he forwards a report to magistrate,
yes.
he should make those disclosures, whichever is needed.
No, my lord, what I am saying is that, my lord, no, my lord, two parts, my lord, with all respect, I'll submit. One is regarding recording of that reasons or whatever we call it. And secondly, my lord, is it mandatory that the moment a FIR is registered, FIR is lodged, it has to be registered? There is no application of mind is required?
But the discretion lies with the authority.
No, my lord, it's no, my lord. That discretion lies only in case of 156. In case of cognizable offence, there is a requirement, my lord. Now, kindly see para 41 in this case, my lord. Para 41 at page 359.
Yes.
Para 41. We shall now examine as to what are the requirements to be satisfied by an officer in charge of a police station before he enters the realm of investigation of a cognizable offence after the stage of registration of the offence under section 154(1). We have already found that police have under section 154(1) of the code a statutory duty to register a cognizable offence, and thereafter under section 156(1) a statutory right to investigate any cognizable case without requiring sanction of a magistrate. However, the said statutory right to investigate a cognizable offence is subject to fulfillment of the prerequisite condition contemplated in section 157(1). With all respect, I am laying emphasis on this, my lord. However, the said statutory right to investigate a cognizable offence is subject to fulfillment of the prerequisite condition contemplated in section 157(1). The condition is that officer in charge of a police station, before proceeding to investigate the facts and circumstances of the case, should have reasons to suspect the commission of an offence which is empowered under 156 to investigate. Then my lord will kindly come to the last three sentences. Kindly see, my lord. Thereafter, in the Code of Criminal Procedure of 1882, a provision, namely section 157, which was identical to that of the present section 157, except for some variation in later part of that section, was introduced, which provision also required police officer to have reasons to suspect the commission of a cognizable offence. May it be noted that Law Commission of India in the 41st report expressed his opinion that section 157 did not call for any amendment. My lord, in my humble submission, my lord, what is required to be looked into by the investigating officer is whether the ingredients of the offence alleged are there or not. Now, I have shown, demonstrated, my lord, none of the sections are attracted. So, all that I am trying to emphasize for your lordship's kind consideration is what is mandated by second proviso is that before proceeding to investigate, the investigating officer must have due regard whether the requisite ingredients which constitutes the offence are present. If it is not there, my lord, even in Niharika's case, para 32 3.3, Honorable Supreme Court has said, if the taking the allegations in its face value, it does not contemplate the offence, then, my lord, it's a case where an interim order is called for. That is my humble submission, my lord. Then, my lord, one more paragraph at para 48. What is that reasons to suspect? Para 48, my lord.
Yes.
At page 361. One should not lose sight of the fact that section 157(1) requires the police officer to have reasons to suspect only with regard to the commission of an offence which is empowered under 156 to investigate, but not with regard to the involvement of an accused in the crime. Therefore, the expression reasons to suspect the commission of an offence would mean sagacity of rationally interfering the commission of an cognizable offence based on the specific articulate facts mentioned in the first information report as well as in the annexures. My lord, prima facie, the allegations must constitute, the ingredients must be inbuilt. Otherwise, my lord, the investigating officer does not derive the power to go ahead with the investigation. His only a course of action open is to, my lord, not to investigate when he finds that the requisite ingredients are not there. Now, I have already submitted, my lord. Kindly see what is the allegation. The allegation is, my lord, some very vague allegations. Where are the ingredients to constitute 506, my lord? 406. Where are the ingredients to constitute 420? Where are the ingredients to constitute 426? And, my lord, 500 has been, I do not know how they have got it. There's nothing like on a police report, my lord, an FIR can be for criminal defamation can be done, my lord. And 506, my lord, what is that criminal intimidation? Other than mentioning the word criminal intimidation, what is that, my lord, material which is evident from the FIR that there is an intendment to cause alarm, my lord? Where is that? There is none, my lord. So is it not a case in my humble submission, my lord, where on account of some, my lord, I do not know, my lord, why this FIR has been lodged. And I'll demonstrate, my lord, why this allegation of 1500 crore is wrong. If your lordships would kindly come to page number 24, my lord, for a moment of the petition. Roman 6, my lord, para. During 3823 to 11923. So according to the, my lord, the FIR also, these are the 13 days during which, my lord, according to them, the state has lost 1500 crore. The number of schemes notified by the state of Meghalaya and total number of tickets along with the total number of scheme is provided. So these are the, my lord, different schemes. Now please come to Roman 7. That from the above table it is evident that total MRP value of the tickets involved in the scheme between 13,823 and 11,9 was 67 crore 59 lakhs 18,880. However, after payment of the price and applicable GST on sale of lottery tickets, the amount left for distribution as profits between distribution network and the government would be less than 28%. A calculation of the said profit margin is provided herein below. Now, if your lordships will kindly come to the second subpara. Therefore, the maximum loss government of Meghalaya could have incurred during the that is 3823 to 11,9.
These are calculation given by whom?
Yes, madam.
That
No,
is
these
your
are, no,
calculation.
no. They say that based on the FIR only we have worked it out. Schemes.
These are disclosure made in the FIR.
FIR, yes. And my lord, in terms of this scheme, only it covers 13 days. And according to us, my lord, assuming that the allegation is correct, then the loss which will be caused is only 37 lakhs 13,498, not 1500 crore, my lord. And scheme itself is there, my lord. 154 is the scheme, my lord. The notification issued by the government, my lord.
Yes, Mr. Sulai.
So, my lord, therefore, my humble submission is, my lord, lordship will hear the matter at an early date. Till then, lordship will protect us, my lord.
Then notice be issued, your lordship. I'll have instructions. So far, I could understand, your lordship, they are trying to stall the investigation. Your lordship, kindly see, your lordship, this is an FIR of 2023 and September 2023, your lordship.
There is no apparent need of stay, isn't it?
Lordship. Lordship, the FIR mentioned in paragraph 9 and 10, your lordship. These, your lordship, whether those allegations, your lordship, are reliable or genuine or not, these are matter to be investigated, your lordship.
But then, so far as plain reading of the FIR is concerned, where is the offence under, except for 506, there is nothing.
No,
All
lordship,
other 406,
lordship,
420, all those things.
I would not make a comment on that. Well, lordship, kindly see, your lordship. The matter is still under investigation, your lordship. We do not know, your lordship. let the investigation go on, your lordship.
No, but this FIR is already 1.5 years old, isn't it?
Lordship, yes, it is.
What is the status of investigation?
Lordship,
now?
I'll have instruction. Your lordship, as I have submitted, your lordship, it is a FIR of September 23. Where is the requirement for stalling the investigation, your lordship? They have approached this honorable court, your lordship, also after a year, your lordship. So let the notice be issued, your lordship. I'll have instruction. So far, the stalling of the investigation, your lordship, in my humble and respectful submission, it is not called for, your lordship.
So we'll consider your interim prayer on the returnable text.
Milord, can I make one prayer, Milord?
One thing is that
No, regarding
whatever the
506, if regarding 506, would your lordships kindly permit me to place two paragraphs from two judgments, Milord? Regarding 506.
See, we are on to those things. You see,
Yes.
rightly or wrongly, FIR speaks about something, whether we do not know what is correct or not.
Correct.
If you scrutinize it properly, then many things would come out.
Yes.
So we may not go into all those things.
No,
under
Milord,
policy.
prima facie, Milord, even 506 ingredients are also not there, Milord. That's why only two paragraphs from two judgments, Milord. Please kindly permit me.
See,
Because
one
I'm
thing is
praying
that
for
the
an
fact-
interim
the
stay,
fact
Milord.
remains- one
Who
thing
knows,
is just
Lord?
the fact remains that you have approached this court after 1.5 years of the So that is one thing, see.
No, Milord, we got to know only recently regarding this.
See, whatever it is, you see, if nothing has happened in 1.5 years, nothing is going to happen within 2 months.
No, Milord.
We will just allow Mr. Shulai to have instruction, and then we'll pass on.
At least, Milord,
order regarding-
at least they will not take any coercive measure, Milord.
See, now.
At the
now we are
Niharika's
more
case
particular.
only.
After that, what is that Ernest Kumar case?
Huh.
It cannot be. These are all.
No,
punishment below 7 years.
Niharika's case, Milord, if your lordship will kindly permit me to place Niharika's case, Milord, when,
No, we're
in
talking
what
about
situation
the
lordship
punishment,
can
see.
pass an interim order?
See, the coercive, so far as your apprehension
Yes.
of coercive action,
Yes.
that it is not there. These are.
This is
41,
below
section 41.
7 years. Most probably these are below 7 years, your lordship.
So
So
that fear is not there. Police cannot go and arrest you
lordship, yes.
without issuing a notice under section
No, my
41.
humble submission is, Milord, if I can satisfy your lordships that it's a case where the ingredients are not there, lordships will not permit them to investigate. That is my case, Milord.
But then the
Yeah,
fact-
because I am not saying that they cannot register a case. They have registered the case. But before you decide to investigate the case, in fact, my lord, Bhajanlal's case, I have read the para 35, 41 and 48. It's clear. In fact, my lord, para 48 is very explicit. It says you will not proceed unless you are satisfied. No, my lord, on what basis they are satisfied? That's why I was trying to place two paragraphs from two
What
judgments
is the
for
current- what is the-
506.
What
my
is the current status of the case?
current status, my lord, they are investigating. Case is going on. And prima facie lordship will see they have come up with an allegation that there is a case of 1500 crore loss. Whereas we have demonstrated, my lord, it is not even 37 lakhs, assuming the allegation is correct. And my lord, regarding 506 also, where is the constituents, my lord? Where are the ingredients? Please permit me to place two paragraphs from one judgment, my lord.
You can permit this.
Yes.
Alright, but then-
My lord, that judgment is 2015 7 SCC 423, my lord, and I am giving the judgment, my lord. Please,
Why don't you give us also?
give you, we'll give you.
Give us also.
Yes,
Don't keep in your pocket only. You keep
we'll give you.
So,
We'll give, definitely give. My lord will kindly come to page number 181. Page 181 of that compilation, and relevant portion is at 185. Page 185. 185. At this 185. Please. Milords will kindly come to page 185. At para 11, 506 is quoted, Milord. Now, of course, Milord, by virtue of the state amendment, here it is cognizable, Milord. Otherwise, the Central Act, it is not. Yes, yes. Please come to para 12 at page 186. In the instant case, the allegation is that appellants have abused the complainant and obstructed the second respondent from discharging his public duties and spoiled the integrity of the second respondent. It is the intention of the accused that has to be considered in deciding as to whether what he has said, what he has stated, comes within the meaning of criminal intimidation. So, my lord, this is very clear. The Threat must be with intention to cause alarm to the complainant to cause that the person to do or omit to do any work. Mere expression of any words without any intention to cause alarm would not be sufficient to bring in the application of this sanction. But materials has to be placed on record to show that intention is to cause alarm to the complainant. My lord, applying the test laid down by the Honorable Supreme Court to the facts of the present case, where are the averments, where are the materials, my lord, to cause alarm, my lord? Kindly see the, come to the FIR once again, my lord. Sorry to trouble your lordships again. At paragraph 9, it is at page 143. It is pertinent here to mention that the said Martin Santiago, through their associate Mr. So-and-so, henchmen and gangsters, gave continuous and serious threat to the stockists, sub-stockists and others, and thereby prevented them from carrying out the business within the Meghalaya State Lottery. The said illegal activities carried out by Martin Santiago and his associate through their antisocial element caused huge business loss to the Meghalaya State Lottery, approximately to the tune of so and so. So they are coming to a different conclusion that these acts have caused monetary loss. They are silent about the basic ingredient of criminal intimidation, which is that threat, holding out a threat with an intention. What is the intention? Intention is to cause alarm. Where is that, my lord? So therefore, my humble submission is, my lord, lordship will kindly protect us, and lordship will fix the matter early. We are prepared. We will argue the case any date to be fixed by your lordships. And my lord, finally, that Niharika's judgment, my lord. One paragraph from Niharika. Niharika wala kahan gaya? No, my copy. Ah, it is there. Go talk to court. Give one copy to them. My lord will kindly have para 33, my lord.
This is not included in your compilation. It is not there.
No, it is not there, my lord. Niharika is not there in the compilation. Conclusion, para 33. In view of the above, page number 454, my lord. In view of the above, and for the reasons stated above, our final conclusions on the principal core issue, whether High Court would be justified in passing an interim order of stay of investigation or no coercive steps to be adopted during pendency of the quashing petition under section 482 CRPC and or article 226 of the Constitution, and in what circumstances whether High Court would be justified in passing an order not to arrest an accused or no coercive steps to be adopted during investigation or till final report charge sheet is filed under section so and so, while dismissing, disposing, not entertaining, not quashing the criminal proceedings, complaint, FIR in exercise of the power under so and so. I'll have your lordship's kind attention to 33.3. It is only in a cases where no cognizable offence or offence of any kind is disclosed in the first information report, court will not permit an investigation to go on.
Not the case here. It is not the case here.
Then lordship kindly come to 33.5.
With all respect, I'll submit, my lord, subject to
33.5.
eventually what your lordships may say. My lord, it's a
Anyway,
case.
Mr. Sulai,
Lordship.
one thing, you take instruction,
Lordship,
but then
yes.
don't take any coercive action.
Yes.
Returnable.
These are 7 years or below 7 years, your lordship. Notice will have to be issued, your lordship.
Even then, you see, you have nothing you have done in 1.5 years. Okay. So there is no harm if we pass that order. If we
I
protect
can't
them,
say, your lordship, whether it has not been done or not. I can't say because I'll have to have instruction.
No, we'll pass that order. We'll protect them. See, the main case, you have filed a separate case for.
Yes,
Yes. In the both the matters are same. Item number
same,
1 and
same,
2.
my lord.
Yes.
Second is by Mr. that Nagaraj.
Yes. Just say the first thing. Third Mr. came to the senior counsel, assisted by And so, for the petitioner, issue notice, the returnable in 2 weeks. Mr. M.D. Shulai, learned AG, appears on learned AG along with Ms. Art Corley, learned G, appears on behalf of the state respondent. When can you have instruction?
Let me have instruction, Your Lordship.
We'll have it after 2 weeks.
Lordship, yes.
What is the issue? Notice initially say returnable after 2 weeks. Then in the last part, list this matter after 2 weeks. Okay, and then come to the miss case. Here also, hard learned counsel for the parties. We just say issue notice on the interim prayer. List this matter after 2 weeks. In the meanwhile, no courtship action be taken against the petitioner.
Deeply.
In both the matters,
Would your lordships kindly fix a date, my lord, after 2 weeks?
you collect the date from them.
My lord, only thing is 12th I have some difficulty. Any date after 12th.
Yes, fix any date without accept.
No, I have a difficulty. Oh, holiday here. I am told it's a holiday. Then no problem, my lord. Even 13th I have no issue. As the court master will give the date. I am deeply obliged.
Obliged, Your Lordship.
Item number 3. Yeah.
Yes, madam.
May I please, Your Lordship?
Yes.
This is also a petition under section 482 and 523 of the BNSS Act. This is a case, Your Lordship, for praying for quashing of the FIR. Here, Your Lordship, both the petitioners, they are very senior citizens. One is around 84 years and the wife is around 75 years of old. And petitioner number 1 is a cancer patient. He is suffering from throat cancer and struggling for fighting cancer for last several years. Now, they have two children. A younger child is settled in USA, and this is the elder son, who is a dentist himself. And both the petitioners are medical practitioners. Petitioner number 1 is a renowned eye specialist in Shillong, and petitioner number 2 is also a medical practitioner doctor. She was working in Nazareth Hospital. Now, respondent number 2, petitioner's elder son got married to respondent number 2, and this is his second marriage. His first marriage was divorced by mutual settlement, and he has 2 daughters from his first marriage. This is his second marriage, and in fact, with respondent number 2, and respondent number 2,
Respondent 2 is the wife of second wife of his son.
of their son, and she respondent number 2 also it is her second marriage with him. She has a child from her first marriage. And this petitioners herein, they are permanent residents of Shillong, and they allowed their son and respondent number 2 to stay in their ground floor of their house as a rent-free accommodations. There is no, on the day-to-day basis, there is no interaction with them because they have separate entry to their house. They have separate kitchen. It is not that they are living together. Separate independent matrimonial life they are leading. And both the respondents are, means the son is being a dentist. He regularly goes to his clinic. And the respondent number 2, their daughter-in-law, who runs business, she has 3-4 shops in Shillong. So the whole day she is out and comes back quite late at night. So on daily basis, there is no such regular interactions or any sharing of any thing in their life. Now, of late, they have seen that the relation between the son and the daughter-in-law was not going well, because they could hear them arguing every now and then. But there was no interference from the parents in their event, because they both are mature people, second marriage, so they have never interfered in any of their event. Now, they were shocked that recently again they were fighting, and on 22nd of May, both the son and the daughter-in-law came up to their residence. They were fighting and arguing and abusing with each other. At that moment, when the parents told the respondent number 2 to calm down, she became violent, and in fact, she attacked the father-in-law by throwing things at him, by throwing things at the TV and all that. And when the situation was very violent, they had to call one common friend to calm down the situation, because both the parents are very senior people. After that, both parents, because of this, because he needs a calm and peaceful atmosphere to lead his life. Being a cancer patient, he is not physically not fit to undertake any stress and mental tension. And this day-to-day fighting and arguing and abusing, what the respondent number 2, she will go out, stand in the veranda, keep abusing the family members. Entire neighborhood comes to know, which causing a lot of embarrassment to the parents.
You are challenging FIR
FIR,
closed by respondent number 2.
respondent number 2.
Can he come to the FIR?
Yes,
Before
I'll
you
compare.
go
I'm
to
just
your
giving the
personal
background why. Because at that moment of time, the respondents, the petitioners, had taken this most difficult decision of disowning their son, because they are not in a position to face all these things in life, and just to lead a peaceful life, they have disowned their son in May 2024.
They are not connected to the
In
family
any
affairs.
manner with them. And after that, they have asked the son and the daughter-in-law to leave their house, to vacate their house, and they have vacated in July 2004, 10 July, they vacated the house. Now, your lordship, they were shocked that notice has come from the police station asking them for investigation, calling them to the police station to record their statement, and then that they came to know that there is an FIR filed by respondent number 2. My lord, I will take your lordship to the FIR now. In this FIR, your lordship, there is no specific allegation as such against the parents. If your lordship will see, the FIR is at page 31, which has been filed by the respondent number 2. Now, only the allegation, very vague allegations, if para 4, if your lordship comes to para 4, only where I will just take your lordship to where about the parents it is written. Para 4, it is written that my husband Sri Kamaljeet Singh Sadeb and his parents have subjected me to years of abuse. Now, Sri Kamaljeet Singh Sadeb has been involved in an extramarital affair, and whenever I confront him about it, I face both physical and verbal abuse. His parents also regularly subject me to verbal abuse. Moreover, my parents have been repeatedly humiliated by both my husband and his parents. No specific date or anything, just an allegation. Then again, at para 7, my lord, that I wish to state that my husband's parents were fully aware of the physical abuse I endured, yet they choose not to intervene. In fact, whenever my husband assaulted me, my in-laws made no effort to stop the abuse in any way, but have always encouraged him to be violent against me, and have also regularly fed him with cooked up stories and scenarios. His parents have always taunted me for not being a Punjabi, and thus I am inferior to them. So when, on which date they have done, or in which year? Now they have been married for 7 years. So if there was so much of abuse over the years, whether she has filed any complaint anywhere earlier, anything, nothing. That, you know,
Can you scrutinize the FIR the way you are trying at this stage in 482?
No, my lord.
What is the limit of the jurisdiction of the court?
My lord, court can, the recent decisions of the Honorable Supreme Court is also there, you know, especially when 498A. If your lordship will see, even the police FIR, if your lordship will come to, page 23, my lord, here, date and time of occurrence is written from June to September 24. Is only in between June to September 2024. Here, my lord, we have disowned him in May 2024. In May. That means till then there was no occurrence for filing the FIR. There was no grievance or nothing. And in
Now,
July,
when you disown your son,
yes,
she moves along with
yes, we have,
along with her husband. I mean, like,
yes,
she did not. She was there together. With
I
her
have
husband.
disowned, and after that I asked them to vacate, both of them to vacate the house. And on 10th of July, both the respondent number 2, along with her son, all of them, they vacated the house. They asked for some time, and after that they vacated the house.
And this FIR was filed
In November, 16 November, my lord. On the face of it, if your lordship will see, date of offence is June to September 2024. Then these are all false allegations that for years of abuse. But in your FIR, your occurrence is only from June to 2024, not even a month after I disowned my son, and in July 10th, we have vacated the house. My lord, I have enclosed this document here my disownment where I have given public notice. Being a parent, Your Lordship, you will see, being a
is there-
parent, they have taken this hard decision of disowning.
Is there any statement made in the FIR
My Lord.
that they vacated the house in May 2024?
Yes, because
Where
I
is
have
that?
the letter also, my Lord, here
No,
in
we
the
do not
FIR.
have we
She
cannot
has mentioned.
see. We
She has
cannot see.
mentioned, my Lord.
We cannot see your document.
Yes.
Version
Well,
of your story has no value at this
yes.
stage.
Well, in the
Please show
FIR she has
us-
mentioned. Yes,
Yes,
here.
please show us where it is.
Mm. Para 10, my Lord, page 33. Page 33, para 10. Thereafter, my husband received a notice dated 25 May 2024 from my husband's mother demanding that we vacate the house where we were residing at the time, and I was caught off guard. The notice came unexpectedly and was soon followed by an even more shocking development, a public announcement in a local newspaper where my husband's parents declared that they have disowned him, severing all family ties. The emotional impact of these actions was immense for me as I was already grappling with the burden of a difficult marital situation. Having gone through the pain of a failed marriage in the past, I was determined not to let history repeat itself. So here she have mentioned that you have disowning.
That is okay, but then where you have said they have moved away?
In my petition, after this, in my
This-
petition, I have
in this
stated that they
FIR,
vacated on 10.
Is there anything?
Yes, there she is mentioned below. I decided to follow the course they had set in motion, hoping that compliance would bring some stability to our lives. On 10 July 2004, we moved to Lapalang. That they have left. So, where is the scope of the parents causing inequality or harassing or anything? And
The
these
FIR comes in
under
November, isn't it?
yes, on and the sections of 498A, 498A and 323. Your Lordship, 498A also, none of the ingredients of 498A has been made out even from the because it is not her case that there was dowry demand or anything. Whoever causes cruelty to a woman demanding, coercing her for making any dowry demand, that is not the case, Your Lordship.
This
Here,
case is registered under what section?
498A and 323. And nowhere she has mentioned where we have physically the parents. I'm talking about the parents, my lord, here only. Because only thing, my lord, here your lordship will appreciate these the
Husband is not a petitioner here in this case.
no, this is only parents have come that and 498A, also latest decisions of Supreme Court are there. So they say the tendency is that family members, husband and wife may have some marital relations. We are not concerned about that. But parents and in-laws and relatives are unnecessarily dragged in most of the cases. And the recent decision of Supreme Court is also there where court has well, this is a case of 2024.
That relative of the husband should not be dragged unnecessarily.
Should not be dragged. And my lord, in this case, what has happened? The father is 84 years old and he is a cancer patient. And the wife is also 75 years old. She has to take care of him. And now the winter season is coming. They cannot reside here during the cold winter season. They have to move out. And if this kind of criminal matter is pending, and that the sword is always hanging, the tension, which will also adversely affect his health, my lord. So since prima facie there is no such allegations against the parents as such, so continuing with the investigation and the trial is not required. So
See, this is an FIR which does not name you only, it names the husband.
Husband, correct, Your Lordship.
So there is no question of, you see, like staying the FIR at this.
Cautionary
so far as
FIR.
no, so far as against the petitioners, my lord.
and
I am not
even-
talking about the thing. So far as the
even you may be
petitioners are
needed.
concerned, my lord.
These are matrimonial offences. Even you may be needed so far as the investigation is concerned.
No, we are already, my lord. They have come and taken the statement or recorded the statement of the petitioner number 2, petitioner number 2. Because the husband being suffering from throat cancer, he cannot speak properly. His voice is also not clear.
So your statement is, the petition
Yes,
number 2 statement has been recorded.
Yeah, already recorded petition statement. So at least against the
So at
parents,
least
my lord.
you do not have a threat of being taken into custody.
Yes, Your Lordship, because notice under
But then
section
the tension
35(3)
will
has been
always be
issued,
there,
Your
my lord.
Lordship.
Yes, notice has
Tension
been
is there, and
issued.
this is
35(3)
unnecessarily why they should be made to for, because in the FIR prima facie only do not disclose any thing against allegation against them. See, such all vague allegations, no specific allegations made against them, and the law is also very clear that if only on vague allegations, no proceedings should be,
But then,
criminal
see,
proceedings should be set into
if
motion.
we pass any order staying the investigation, that will mean investigation would stay against the
Against the
husband also.
husband also, your lordship, because the
So,
FIR is against the
so
husband and
only
the
thing is
student.
that you need protection, isn't it? So that is what should be done.
But your lordship,
Otherwise,
the very fact that notice under section 35(3) BNSS Act has been issued,
That is what the
so
investigation.
it
they are
shows
doing.
that there is no need. They have stated that this notice is issued only when there is when they feel that there is no
but then
need to
the senior
arrest.
counsel has submitted that a statement of petition number 2 has been recorded already.
Recorded.
Also,
Yes.
your
Then
lordship.
thereafter again notice.
No, that was prior.
Oh,
That was
prior to
prior
the
to the
notice.
statement being
So the
recorded.
notice has been complied with. So that
Yes,
you do not
then
have
there
to
is
fear.
no threat.
We'll issue notice.
There's no apprehension
Then
of
only
arrest.
then they will not be able to go out because they are also planning to
where
go to
is
the
it?
States for 6 months.
Until and unless that
That is-
restriction is made, I don't think.
But investigation
any-
and
if
the
any
FIR
such
cannot be
comes,
quashed
Let
at this
notice
stage.
be issued and then
Yes, we will be issuing notice. There is no question about it. We will be issuing notice.
To
But
the
so far,
private
see,
respondent also, your lordship.
any interim order at this stage,
at
causing
least
the
some protection
total
if your lordship
stoppage of investigation.
is
Would cause
is
severe
something,
prejudice,
see,
your
like we,
lordship,
the
to the
husband will get involved. And since you have not been made an accused till now, the FIR may be lodged against you. The police has not taken any decision of making an accused. Okay, so that is what we'll do. One thing,
We'll take instructions, your
notice.
lordship, because the quashing the FIR, your lordship, would mean that
and
the
if
entire
any
investigation
restriction
would be.
comes, we approach us again.
my lord.
If any restriction, any such restriction come,
Right.
as you are apprehending, you can approach us.
No,
again.
definitely, my lord. This also affects the health of the petitioners because criminal proceedings, all as it is, gives lot of tension, and then one cannot
our role
even breathe
is-
normally under these circumstances when a criminal matter is
We
pending.
can
my lord.
understand your anxiety, but then you see, like there are many situations we cannot give you a complete relief. So one thing is good, at least the police has not gone and taken it to you custody. You have complied with the notice. That is one thing.
Statement has been recorded, your lordship, and because the FIR is against all three, so quashing the FIR
Well,
is
a
great
notice
for
may issued
them.
with some
At
interim
this stage
direction
would
that they
be
should not be harassed or for this.
So the same thing, coercive step. No court. You do not take any coercive step against them.
we haven't. Otherwise,
it is-
notice under
that may be
35 has
noted
not
also no
been,
course.
would not have been issued.
Let
your
notice be issued and
The statement has been recorded, section 35(3)
If
has
you say us that you will not take any coercive action, as we will record it here.
No, I mean, we have already issued notice under section
that may be
35.
recorded,
So
my
I
lord.
do not think that there's any threat
So that is then
against the petitioners.
So
but
we'll just say, we'll record it, that you say that no coercive step would be taken.
against the
There is no
parents.
problem in it.
against whom, your lordship?
Against
these-
petitioners,
these
the
two
parents.
petitioners, not against the husband.
Your lordship, since they are senior
Yes.
citizens and ailing, I do not think there is
That
any
is
threat
why- that is
otherwise.
what- that is what-
But
that
then
is-
the quashing of FIR, your
You have filed a
lordship,
separate miscase for interim. No.
No.
no,
ma'am.
they have
Yes.
not filed.
It's not required actually.
Yes.
Heard Miss PDP Godwa, London Senior Counsel, assisted by so and so for the petitioner. Issue notice. We returnable in 3 weeks. MST Youngie, learned AG, along with so and so, Achungla, MS Achungla. Appears for the respondent number 1. Step. The petitioner shall take step for service of notice upon the respondent number 2 within 2 days.
Yes.
Then just say at the interim. No. Heard the learned counsel for heard the learned counsel for the parties on the interim prayer. Stop. It is submitted by MST Youngie learned AG that since the petitioners have responded to the notices issued under section
35(3).
35(3).
of BNS of
BNSS.
BNSS. Comma. There is no such serious apprehension that the petitioner will be taken into custody. she submits that there is no likelihood of any immediate coercive action against the petitioners. And here the submissions do not say this, just say submissions made by the learned AG has been taken note of. And no interim taken, just give a footstep, just say list this matter after.
Lordship, this pending of this writ petition should not stall the investigation, Your Lordship,
That
because
is-
the
that is-
husband's,
that is- we are
the
not doing
husband,
investigation. We are not
no,
That is
because it may not be, it should not be interpreted as
Just-
that, no?
Just
Because the
before
husband is
before
still
before
there.
you say list before these things, what he said that the last time, what is the submission of these things?
My lord, if
Yeah, but
lordship
you-
directs also requires
okay.
that no coercive action may be taken in view of the submission, no coercive action may be
No,
taken
I don't think
at
that
this
is okay.
stage.
Submission has been taken due note of that is good enough. Just see just tell the last things. No, before that what he said? Before he said the learned AG submits that since the petitioners have
Serious
since the
apprehension.
petitioner has responded to the issues issue under so and so section so and so, there is no serious apprehension of petitioner being
Taken into custody.
no serious of taking of any coercive action against the petitioner. The
That's
submission has been taken note. That is good enough for you, I think.
Then, Your Lordship, this,
So it-
because the police might interpret it that
no,
since the
there is no. this, since we have-
investigation should not be,
But
you know,
there
it
is
should
no
not be
prayer
an
for
embargo.
stalling. We have not prayed
So-
for installing investigation.
No, they have
so,
prayed
so
for
no
quashing
specific
of the
direction.
FIR.
If you say that this should not be taken as a bar for investigation, there is no problem in it also.
Yes.
So
If
they
the
did
submission
not.
has been taken due note of, just a minute. Just a minute. So it is made clear that pendency of this matter should not come in the way of the investigating authority insofar as the investigation of the matter is concerned.
Oblige, Your Lordship.
List of requirements.
Oblige, Your Lordship.
Date speaks.
3 weeks.
3 weeks.
Obviously.
Daily cause list, item number 1